Okay. Board of Directors, I stand before you today as a concerned member of our Windermere Oaks Water Supply Corporation, driven by a profound commitment to upholding the integrity of our member-owned and member-controlled water supply corporation. It is with this unwavering dedication to safeguarding our corporation's welfare and values that we, the members, come before you to present a removal petition representing the voices of many within our membership. We, as concerned members, believe in the principles of transparency, accountability, and integrity that underpin our corporation. It is in that spirit that we bring this petition forward. We are not seeking division or discord. Rather, we are advocating for the betterment of our corporation and the protection of our members' interests. Our petition calls for the removal of two long-serving board members, Dorothy Taylor and Rich Schaefer. Our reasons are rooted in a deep concern for the well-being and integrity of our corporation. We are pleased to inform you that we have obtained the required 10% of the member signatures as stipulated by our bylaws to request a removal meeting, which, as you can see, are here, and we have surpassed that 10% greatly. This demonstrates the seriousness of our concern and the widespread support with our membership for this action. Both Dorothy Taylor and Rick Schaefer have exhibited actions that raise serious doubts about their ability to fulfill their fiduciary duty for our members. Let me provide you with the specific examples. Number one, misappropriation of member funds. Ms. Taylor and Mr. Schaefer endorsed the expending of membership funds to pay Joe Gimenez to serve as the public information officer beyond the limited time allowed for his position, a clear violation of the law. Mr. Gimenez has received over $4,000 of membership money inappropriately and without any demand of repayment to the members. The board was made aware of this and failed to act on this. This raises questions about their stewardship of our financial resources. Surcharges. In our tariff, both Ms. Taylor and Mr. Schaefer voted to include surcharges in our tariff, effectively granting this board the authority to impose any surcharge on ratepayers at any amount without any input or oversight from the members. This unrestricted power places an undue financial burden on our ratepayers. Luckily, Directors Ffrench and Walker and Anderson voted this down. Indemnification vote. No shocker there. Ms. Taylor, without recusing herself and without signing a conflict of interest prior to the statement and prior to the vote, participating in a decision to indemnify herself. This action raises ethical concerns about self-interest and conflicts of interest within the board. Ms. Taylor and Mr. Schaefer have endorsed the idea, no joke, of bankrupting our water system if rates are lowered, with the potential to cripple the very system we rely on for our water supply. This alarming stance indicates a prioritization of legal fees over the stability and welfare of our corporation. Additionally, board members Taylor and Schaefer have authorized legal spending nearly $2 million. Now given the compliance filing at the PUC, clearly will continue this legal spending to fight than simply acknowledge the violations uncovered. The PUC compliance issue that was just filed. The PUC recently filed a compliance report highlighting that Windermere has not operated as a member-owned, member-controlled, nonprofit corporation for an extended period. These issues include changes to our bylaws without membership vote, multiple election irregularities, and non-compliance with our bylaws regarding member definitions. All of these matters have occurred under the supervision of Ms. Taylor and Mr. Schaefer. The PUC compliance filing on all these issues with our election changes, changes to the bylaws without membership votes, etc., are all of great concern to the members, and it is just too much to sit by idly and do nothing. We do anticipate that you will, as you have always done, engage Lloyd Gosselink, your attorneys right here, to spend even more of our money defending your position on this board. However, given the recent compliance filing at the PUC citing election discrepancies and the fact that the GM, George Burris, and Lloyd Gosselink have involved themselves in our elections, we urge this board to think twice before these parties are involved in any of these special members meeting processes. We, the members who have signed this petition right here and represent 10% of the members, hereby additionally request to call this special meeting under the provisions of the Texas Business Organization Code, Section 22155, which states that members having not less than 1/10 of the votes entitled to cast at the meeting may call a special meeting. We are recommending 3 dates of October 21st, October 28th, and November 4th, 2023. Please also keep in mind that because 2 directors have been named as the directors for recall, we believe they are unable to participate in the issues related to this meeting, as this is a conflict of interest. Ask you, Secretary Treasurer, to recognize the gravity of these concerns, to heed the resounding voices of our membership, and fulfill your duty by accepting our petition. The special meeting will provide the membership with an opportunity to decide the fate of continued leadership roles within our corporation. I thank you for your time and consideration. And one thing that I'd like to add, if we have them all here, that I'll hand over to you. I've consulted with the attorney to ensure that we have a fair opportunity to have this recall meeting, and that there are no hijinks, there's no issues with your attorneys trying to challenge us because of the fact that we don't have a legal background. So I have reached out and consulted one to make sure that our rights are upheld with this meeting. And that is it. With that, I'm going to hand over all the petitions to you, Secretary Treasurer. And as required, I'm giving a copy of the charges that we have to you, Ms. Dorothy Taylor, and to the President, Mr. Schaefer. Thank you very much.
Danny,
I'll let Jeff go first.
Danny,
I'll let Jeff go first. Go ahead, Jeff.
Good evening, everybody, and thank you for coming to our meeting. I did not know that was coming. Did not know at all. I did not know this was coming out on Tuesday this last week. I knew, hang on a second. I knew it was coming. I warned everybody. I warned the previous board. This baby was coming. Now I want you guys to know my name's all over this. But all I did.
What is it?
This is the PUC filing that came out from DICE on Tuesday. 26-page read, the rest are exhibit. I would encourage you guys to take a look at it.
You got 2 copies.
I gave the PUC directions to the runway. I didn't fly the airplane. I shouldn't say I didn't take off. I didn't fly the airplane. I didn't land it. PUC staff did. I haven't talked to them in over a year. And they found this whole thing on their own. This is very compelling. This is, as bad as the rape case. They got most of their information from the rate case, so it's pretty easy for them to put it together. This is pretty bad, if you read this. It's pretty bad, if you haven't had a chance. But, so that's my take on this whole thing. My name's all over, but again, I'm kind of like, I'm going to look for whistleblower status on this one, because I probably tooted my horn a little bit to them, but it's a good read.
You might actually want to say what it is that this is that you're talking about.
I did. I said it was the PUC filing that came out on Tuesday.
That should be on this agenda right here.
Yeah.
It's not.
No, of course not.
Yeah. Second thing I want to ask, think before you answer on this one. How many people in this room do not support lower rates?
Not if it's by the way you're.
Hang on a second. Just show of hands that do not support lowering our rates.
This is not a.
Anybody?
Not interrogatory. You're
Anybody?
I got 3 minutes to talk to me, and I'm talking.
No, you're
Is
asking.
this like, when did you stop beating your wife? Is that the kind of question?
No, I don't have one. Thank you.
Wow.
Thank you for that accusation. So, the reason I'm asking you guys that is I need to ask the legal team, this gentleman right here, because I don't get to participate even though I'm on the board, and the two lawyers over there, did they see how many people do not support what you guys have been doing? Do not support it. You're spending their money. Their money. It's a member-owned corporation. They wanted you guys to stop. We've vocal that for months. And that's pretty imperative right there. A couple of people in the back said we don't support it. Go forward. The rest of the people in here do. They support what's going on with the rate appeal. They support staff. And I'm telling you guys right now, these two gentlemen right here will be writing a letter to the PUC Commission supporting it. It's coming. I haven't done it yet because hopefully the hearing's going to be on the 12th and I'm going to set it in their inbox. You guys want to deal with that? That's fine with me. But that is pretty compelling to the legal team right there. He's the only one that drives it, which is shameful because I'm over here, Rene is over here, didn't ask my opinion on the whole thing. You guys elected me. And this is what this document's all about. Compliance and enforcement. They don't communicate with you guys, and they don't get together as a community to do things. They do it all in a glass box. I can point out half a dozen emails I've sent to that gentleman, and he has refused to answer me. Shameful on him. Shameful. I think I had, anybody want to volunteer their time? There's 2 more minutes. Shameful. Michelle. Shameful. I asked many pertinent questions.
Michelle had already designated her time to.
No, Patty didn't use all her time.
It doesn't matter.
No,
Patty didn't use all her time. Stop it.
Rich,
All right, go ahead.
no, I have to say. Rich, you asked everybody who wanted to see time for Patty to stand up. I did not stand up, so you did not count me. So I'm giving.
Thank you very much.
All right, your 3 minutes starts now. Go.
So, I think that's pretty compelling, especially with our legal counsel here. Now, here's another thing, since our law firm is here, I'm the one that encouraged Rich to invite them to the August 11th meeting. We all know what happened there. I was going to say, get the legal team here. Let them see the vibe of the members out here. Let them look in your eyes, and you guys, let them look to you and say, you guys support what we're doing? Obviously you don't. Kind of sad. Another thing that I have a problem with LG is I think we have a conflict of interest there. Not only are they a corporate attorney, but they're fighting the membership, which is the corporation. How's that not a conflict of interest? Now I know you're going to hear it from them, and oh, it's not this, it's not that, it's pontificating because I heard all that crap from, those people already. I've checked it out with other attorneys, and they're all shaking their heads going, total conflict of interest. And I don't get it. How do you have a corporate counsel fighting the members in a rate appeal case? I just don't get it. Now, with this case, I'm encouraging the other board members, if they're going to fight it, they better review it with the other board people about who they're going to bring in from a legal team standpoint, and they better get a vote on it. Because you guys need to say who's going to use to defend this. It's your money. Not his, not the board's, not the law firm's. Your money is going to have to be paying for it. So keep that in mind. Keep that in mind. That's all I got. I'm going to go back to the other side of the table and represent you guys as a board member.
Yes, sir. My first question is to y'all. If I wanted Anderson here. So the audit's not on the agenda and the compliance filing's not on the agenda, and you had more than enough time to put it on the agenda. And you know that Rene called a meeting for tomorrow and he noticed it. Great, he's here. That's awesome. I'll wait till he sits down. Well, my question's for you too, Jeff. Can't escape this. So Rene has posted a meeting for tomorrow morning at 9:30 at the pavilion to discuss the audit and the compliance filing. Are you going to be there?
No.
Are you going to be there? Are you going to be there?
No,
Why?
I'm going back to Houston.
And you, sire? Wait.
I found out about it a couple days ago. He never called me and asked me about what my availability was.
Well, you knew about the compliance filing, and the audit's been on the agenda for, what, why don't you want an audit?
Which audit are you referring to?
Why are y'all afraid of an audit?
I'm sorry. Go ahead. All right, go ahead.
That's correct. And there's the $2 million man right there. Yeah. Give that guy, give him a big applause.
Yeah. $2 million our money, thank you.
And I'm assuming this guy's being paid by y'all because they didn't vote on it. Who's paying for this guy? Who's paying for this guy? Who's paying you? That's good. If this comes out of if this comes out of WOWSC funds, Dorothy and Rich or the attorneys can pay for it. We're done with y'all. Done with y'all.
Debbie hit?
I gave time to
Okay.
Flunker.
So, I believe that that's it. Did I miss
No,
anybody?
I didn't stand up. My turn. You ready?
Are you listed on here? Let's
Yeah, you
see.
can see it right.
Okay, go ahead.
You need to read my name?
No, that's okay.
Ladies and gentlemen, there's a lot of animosity in this room. It's been going on for 5 years. And that's fine. That's what communities do. People dislike people, but you get along. Like Patty said in the HOA meetings, everybody was nice. It was a wonderful experience. These guys, the opposite. Why did these two people sit and fight? Why are they going to fight this petition? You signed a petition for me to leave this board? I'm embarrassed. I'm out of here, man. What are they fighting so hard to stay on? Look at Dorothy Taylor. Looks at the floor 90% of every meeting. She can't look anybody in the eye. She's the one that started all this by going to Patty Flunker and said, you'll never believe what they did. They sold Van Martin that land. And then she turns around and she finds out who's on the board and who's involved and defends them all these years with our money. You don't have to like people. Nobody's ever going to like everybody. They should resign, save the community, the grief and the money, make this board what it's supposed to be. Represent who you were elected to represent, Rich. You're not. You're not even communicating with those two down there via email or phone call. You don't show up at meetings. We've had 3 meetings in this room in the last 2 weeks, 3 weeks. None of those people showed up. None. No quorum. No meeting. This many people show up, 25 people, 30. Where are they? They didn't bother. They're home. And George, shame on you for collecting ballots. You knew you should have been involved. Richard Crow, you can tell your wife to read the compliance filing. She should have counted my ballot 2 years in a row. It's in the filing, my name. All Janet Crow, playing games for Dan Martin. I'm done.
Step down.
Okay, I believe we are now finished with the public portion of the meeting. Is that correct? Anybody else think that they're on the list that I did? Okay. So, we as you noticed, we have an officer tonight, Cole, what's your last name? Cole MacArthur. So,
Y'all vote for that?
pardon?
Y'all vote to pay it?
So Cole is here to make sure that as we conduct the rest of the meeting,
Who's paying it?
that it's done where the board is conducting the meeting. Your time to speak is now over with.
So are you a
if
policeman?
you-
Is he a policeman?
So the next item on the
Hey,
agenda,
hey, Rich, is he a
Yes.
policeman?
number one.
Is he a policeman? Are you a policeman?
Keep it up. And
Are you a policeman? The people in this room deserve to know if that man's a policeman. Are you a policeman?
I'm not a peace officer. No.
Okay,
Okay,
got it.
you're not a police officer. You represent no public entity.
The next item on the agenda, approval of board minutes. The first item underneath approval of board minutes is April 15th board meeting minutes, April 15th, 2023.
I'd like to make a motion to table that motion.
We
And if
already
you don't
have a motion.
understand that,
We
let
already
me
have a
ask-
motion in place.
Wait a second. No, it's okay. Here's Robert's Rules of Order. I'm paying for it, not even going to be expensed.
And we already have a motion in play.
That's correct.
And-
Would you please read where it's tabbed on how to make a motion,
Okay.
motion to the
So
table?
she made a motion, now you're trying to amend it with a table.
No.
So anybody else want to table this motion? Table Dorothy's motion? No. So you don't want to table Dorothy's motion, so the motion, Dorothy's motion will continue. So Dorothy's motion is to approve the minutes from April 15th as submitted by myself.
That is not correct. That was not stated in the motion. And you do know, if I may pass to you, minutes of April 15th. May we discuss these now?
We're discussing the minutes as submitted by myself.
That's right. Yours are deficient. Yours are deficient. Stated already. Wait,
Before I
wait,
open up discussion.
yes, please, open it up.
Okay, so the motion right now is to approve the minutes as submitted by myself on April 15th. Any second? Any second for that? I will second that motion then. Discussion. Renee, would you like to discuss something?
Yes. The minutes that were passed around for us, that were originally dated April the 14th, and probably written up by Joe Gimenez, and you passed them to the first federal, United First Federal Bank. We got a copy of them, as it turns out, one of the gentlemen that was with me. They are deficient as per the Attorney General's standard. The reason why they're deficient is 2 or 3 different areas. Number one is the open comments period that's specified by the Attorney General needs to be specifically talking about the intent and the coverage of what's happening. That's a violation of HB 2844. You've probably read that. It's part of your policies as well, right, Cole? So the idea is, that's number one. The other thing is that you've already stated, and it's been captured in the minutes on the May 25th, that when someone asked about when the minutes would be provided for the annual, the beginning of the next, just before the next annual meeting, which is correct. However, the minutes that you provided are amazingly deficient in the data that's required to be able to file those draft minutes. That's what's happening. The outcome of the election is not posted on those. So if you would modify yours to put the first paragraph.
The minutes that he's submitting is not for the annual meeting, it was for the meeting after.
That's
the annual
correct.
meeting.
That's correct.
So when you said that it didn't have all of the annual stuff in there, it didn't need to. Those are the ones that are approved in a year.
You're absolutely right. It does not require. However, the formation of what happened in the director's meeting is directly driven by what came out in the election comments. So that's deficient. So if you want to amend yours to be able to put the beginning paragraphs that are there on these minutes, you gentlemen have probably seen them. They've been distributed to all of the board 3 times: July the 27th, August the 26th, and September the 13th. So you've already had a chance to read them, I'm sure, right?
Yes. Yes.
Right. But you guys on legal have already had a chance to read them.
Yes, Joe. I have not read it.
Okay.
Right.
Okay.
They're not required to.
I understand that. However, but if the minutes are deficient, in content, they should not be approved, and they're clearly deficient by the Attorney General standards.
Anything else you want to say?
Yeah, so that's part of it. The other part of it is the intent all the way through. So if you look at the content and the form of these minutes, they're not only accurate, they're precise. The draft that you submitted, or actually that probably Joe Gimenez wrote up, are not accurate and not precise.
Anybody else want to have discussion?
Do we need a legal opinion on this? Does this matter?
Yeah.
Yeah, it does.
Does it?
I don't think we can do the motion. They can always do the legal thing about it after the fact. They're not afraid to do that. So.
I can weigh in right now. I got this.
Oh, Lord.
Okay, hold on. You guys need to be quiet back
I
there.
have the statute. Yes, we do. I have the statute pulled up, and I'll just read it verbatim. The minutes must state the subject of each deliberation and indicate each vote, order, decision, or action taken.
So, there you go. That's what's in the minutes to comply with that.
That's, I'm not a lawyer. Yeah, but your opinion is shallow. I would encourage you to read the Attorney General's TOMA handbook for 2022.
So I just read verbatim what the statute says. I didn't offer an opinion on it. I was just reading the statute.
So, next is, let's take a vote on the motion. All in favor of accepting the minutes on April 15th? Aye. 3. Nays?
Nay.
Okay.
Okay, 2 nays. Okay. Next one.
Would you vote on the next set, the ones that are precise and presented, and the one that's been circulated to the board 3 times?
By the treasurer, the secretary.
By the,
I will take a motion.
Okay. I make a motion that the minutes that are typed up correctly for April the 15th be presented to the board for approval.
A second.
Discussion.
Would you in fact take the opposing side as to why the minutes that have been provided by the Secretary Treasurer are deficient or substandard to the ones that Joe Gimenez wrote up?
I don't need to, but, so thank you. Anybody else want to discuss this? All those in favor?
Aye.
2 ayes. All those opposed? Aye. 3 opposed. Okay. I'll take another motion under approval of board meeting minutes.
I make a motion that the May the 25th minutes that have been provided to the board be approved as presented.
Second that.
Okay. Discussion?
Yeah, I would like to have on the record included in the documentation as well as been published the findings from Mr. Riley that he presented to the community after he did his election audit.
Okay, the totals you need?
Yep.
Okay.
It was nowhere to be found. There was a separate document that was provided. It needs to be on the website. We know why it was suppressed. And I'd like to have it included in the record. It needs to be.
Okay.
And it's nowhere to be found in any of the minutes, and it should have been.
Okay, so it sounds like we're not ready to.
Yeah, we're not ready. At least I'm not ready to vote on it, but I think that's pretty critical. You're leaving out documentation.
You wanna-
You're leaving out documentation from the election.
Do you want to table this then? You want to make a motion to table this item?
I'll make a motion to table it.
Okay, all those in favor?
Aye.
All right, the next item on the agenda is legal issues report. And here we have 2 visitors. As Jeff indicated, he's asked that I bring these 2 gentlemen in. Actually asked for 3, but we've got 2 people here from Lloyd Gosselink. So we have Cole Ruiz, who's our general counsel, and Jose de la Fuente, who's taking care of our litigation issues. So we'll leave them to talk about D&O insurance case, double F hanger lawsuit, and the rate case.
Will they be taking questions?
No, not from you, from the board members.
I have a question for you, Rich, about D&O insurance. Has the policy been updated?
We'll get to that when we do insurance, but so we're talking about the D&O insurance case. All right. Joe?
Sure.
Or Paul, whoever wants to.
No, I'm going to speak to the litigation matters from members of the board. And noted from the members of the board, this is a public session about litigation matters, all of which are technically still open litigation matters. So I will not be discussing any matters of privilege, but I will be giving you an update as to the public developments of the case and procedures that have happened and will happen or expected to happen in each one going forward. So the D&O insurance case.
Please stand so we can hear you in the back.
Of course.
Thank you.
Nobody's ever complained about not being able to hear me, so I will solve that problem. The D&O insurance case, as y'all may recall, is a case that the WSC brought against its insured Allied World when Allied World refused to provide insurance coverage of defendant directors in the underlying litigation. Allied World based that denial on an exclusion language that said contract claims are excluded, which they usually are from insurance coverage. But it based it because there was a contract involved in the underlying dispute. It said that exclusion applied. The board chose to dispute that, took it to the trial court, federal judge agreed with the WSC. The insurance company appealed that to the Fifth Circuit Court of Appeals in New Orleans. The Fifth Circuit Court of Appeals agreed with the WSC and agreed that coverage was provided by that insurance policy and defense costs should have been paid. So based on that, the insurance company decided not to further appeal, to try to go to the Supremes, and they paid all amounts of defense costs that had already been paid for the defendant directors, and they paid, there's a statutory 18% penalty and interest on top of that as settlement. That case is technically still open because the underlying lawsuit is not fully and finally resolved, so there is the open question of whether they will provide coverage on actual claims as opposed to just defense costs. But that case has been abated for now, pending what happens with the underlying lawsuit, and will be addressed if and when that's necessary. So that's where that case stands procedurally. The next case is the underlying case, the double hanger lawsuit, previously updated to this board, and I'm confident most people around here know about the trial in Vernon County last year, the verdict and a final result of that trial, and then that was turned into a judgment consistent with that verdict earlier this year. That finally went final. The process is, the jury decides something, and then the various attorneys present what that means legally and what the judgment should say based on that verdict. That was done. The court issued and signed its judgment. The plaintiffs appealed. The defendant directors and Friendship Homes and Miss Martin cross-appealed. The WSC has not appealed or cross-appealed or taken any action in the appeal. And all those appeals and cross-appeals are pending at the Court of Appeals now. The procedure requires the production of the clerk's record. It's all the papers that are filed in the case. And then the reporter's record, which is the transcript of all the testimony and exhibits that were introduced at the actual trial. Those have to be prepared, they cost money, etc. That takes time. That process is ongoing now, and once that is done, once those are produced, then the clock will start on the parties submitting their appellate briefing at the Court of Appeals. Of course, parties are always free to continue to talk and see if they can resolve things. We certainly hope they are, but that's where it stands procedure.
Question.
Yes.
Has that been presented, I'm just going to say it, has there been a negotiation or a way to settle that case, been presented to either parties?
Well, yes, I can tell you yes, there have been settlement talks because that's public. I mean, everybody knows there have been. As to what all has happened, and I know specifically is privileged, and I'm not going to talk about it in an open session. We have a meeting later with an executive session on this. I'm happy to talk about details and how that might work out, but I just don't want to.
Yeah, I'd like to make a motion that we at some point go into an executive session because I'd like to hear.
Well, we didn't put that on the agenda, so that would do that.
It doesn't matter
I can talk to you individually.
Exactly.
Yeah.
As long as I'm down there.
Right. Happy to talk to you individually.
Okay, that's good.
So that's where that stands. The rate case and rate appeal went through its hearing process in front of two ALJs. The two ALJs issued their, it's called a PFD, proposal for decision. Recommend it approve the rate except for an exclusion, I can't remember the dollar amount, it was 30,000, 80,000, something like that they deemed was improperly counted and embedded in the rate. The parties have submitted their exceptions and opinions on what that PFD should turn into when it goes before the commission. The commission will be taking that up, I think now at their next meeting, September 28th, but I'm not positive.
October 12th.
October 12th. Oh, that's right. The October 12th.
Quite notice.
At the October 12th meeting. They'll be taking that up along with various other items on their agenda, and we'll consider what to do with that PFD. Procedurally, the way things work at the commission is the administrative law judges have heard all the evidence and the briefing and have recommended a decision to the PUC. The PUC can do anything from accept that as is, to reject it entirely and recommend a totally different opinion, to something in between. So that is what the commissioners have in front of them come October.
Clarification on that. Isn't there 3 options for the PUC? Accept staff's recommendation, create their own, or accept the ALJ?
No.
They can't accept staff recommendation?
That's in the middle.
That's one of those things that's in the middle.
Fine, well, it's still in the middle, it's an option for them, okay? I'll do my fingers differently. Commission can do their own thing, they can take staff's recommendation in the middle, or they can do the ALJ, right?
Or they can do something that's different from all 3 of those things.
That's what I said, they can, the number 1, they can do their own thing.
That's absolutely, well, yes, they're
They can do their own
bullseye.
thing, they can take staff's recommendation, or they can do the ALJ.
Yes.
Thanks.
Sure.
Okay.
Would you be kind enough to tell these people how much the rate case has cost us so far?
I do not have the rate case expenses.
Oh, sure you do. It's in the filing.
I don't have them in front of me. So.
And I hate to put you guys in the spot, but who's directing this whole thing? As far as, I've never met you guys, I've never had a strategy meeting about what should we do about the rate case. Since I've been on the board, and it's been 5 months, I'd really like to know why we didn't come to the members and say, what do you guys want to do on this? You want to spend some more money? You want to like settle it? Because I heard that there were some settlement negotiations potentially going on in August, late July, but I'd like to understand who was involved with those. Was that somebody that the PUC came to us on? That Jamie got involved with? That Rich might have been there? I don't know. What was all that about?
I'm happy to talk about that with you offline. I don't want to talk about the privilege matters.
Why is that privilege? These people own the corporation. Help me understand that.
Because some of these people also represent the rate appellants, and we represent the corporation under the existing direction is to pursue and defend the rate passed by this corporation.
Okay, do you understand where I stood up there and said that's a conflict of interest? Does anybody understand that? Right there, it was just defined. That's a conflict of interest, because these are people who pay the bills, but you don't want to tell them because some of the people are in the audience are the ones that are fighting to get our rates reduced. That just kind of like doesn't sound good to me, you know, and I'm kind of a stupid gentleman, but that sounds like a conflict of interest to me. But we can take that offline and we'll talk more about that.
Happy to discuss this with you, Mr.
Okay.
So everyone in the room knows they're teetering on $800,000 on the PUC rate case. $800,000, almost $1 million.
Will you please hold your comments? Thank you. Anybody else want to discuss the, since we have Rene, would you like to discuss anything relative to the double F hanger lawsuit? I mean, you also have the option to chime in here if you'd like. If not,
We're fine.
you're fine. Okay. And Joe, do you have anything else?
I don't have anything else on this litigation.
Good, thank you. Thank you for coming. I mean, we should have had you guys 6, 9 months ago. Just to you know, share with the group what was going on, because I'll tell you right now, I was getting a line of bullshit. And I think a lot of these people were getting a line of bullshit, you know, about this whole rate case for a very long time. And I plan to ask some very, very tough questions
when we go into private session, or when you and I have a talk. Because these people call me about it, and I represent the members sitting out there. I'm not flying on this one solo, and I'm not flying on any case solo, because they're the ones who pay the bills right out there. So, thank you.
Okay, next agenda item then is manager's report.